My name is Gordon MacAllister. I'm 67 years old, and on the coldest Saturday in February, I stood at the edge of a frozen lake in the Muskoka region of Ontario and watched my son-in-law shake hands with a stranger in a suit while my daughter's headstone was still being cut at the Monument Yard in Bracebridge. I had driven 4 hours from Sudbury that morning. Not because anyone invited me, because I had a feeling in my chest that I hadn't been able to shake since Claire's funeral 3 weeks earlier. A low and steady pressure, like a storm that hasn't broken yet. They didn't see me at first. My son-in-law and the man in the suit were standing on the dock at the edge of our family property, the 200 acres of forest and shoreline that my father had homesteaded before I was born. They were looking out at the lake with the comfortable posture of men who are discussing something they've already decided. My son-in-law spotted me when I was about 30 meters away. He said something quickly to the other man. The other man put a folder under his arm and walked toward a silver Audi parked near the tree line. My son-in-law turned and smiled at me. That smile, I'll never forget it. It was the smile of someone who has already spent the money. "Gordon," he said, "I was going to call you this week." I looked at the Audi pulling out onto the county road. I looked at the folder under the stranger's arm, disappearing into the back seat. "Who was that?" I asked. He waved his hand the way people do when they want you to stop asking about something. "Just a contact of mine, a developer. Claire and I had talked about this, you know. The property taxes up here are brutal. She wanted me to look at options. Claire had never mentioned that to me. Not once. My daughter and I spoke every Sunday. We spoke about everything." I looked at my son-in-law's face. He had the kind of face that had always seemed pleasant enough in photographs. The kind that photographed well at Christmas dinners and family occasions. But standing there in front of my father's trees, in front of the dock my own hands had rebuilt 3 times over 50 years, his face looked like something I had never quite seen before. "I understand," I said. I kept my voice even. I had been a construction foreman for 35 years. I had managed job sites with 200 workers. I knew how to keep my voice even when what I wanted to do was very different from what I was doing. He relaxed. That was his first mistake. "Actually," he said, "now that you're here." He reached into the inside pocket of his coat and pulled out an envelope. He held it out to me. "There's some paperwork that needs to be dealt with. The estate is going to take a while to sort out, and I've engaged a solicitor in Toronto to manage the process. He asked me to pass this along to you directly." I took the envelope. I didn't open it. "He said there's a timeline attached," he continued. "The property has to be assessed before April if we want to move forward before summer. So if you have any personal belongings at the cabin, it would be good to collect them before the end of March." The cabin he was referring to was the place my parents had built in 1961, the place where I had learned to fish, to swim, to read a compass in the dark. The place where Claire had taken her first steps on a July afternoon while my wife Margaret held her hands and laughed. The place where Claire had spent every summer of her childhood. I looked at my son-in-law. "I'll take care of it," I said. He nodded, satisfied. "That's great, Gordon. I know this is a hard time, but honestly, the market up here is strong right now, and it's a big responsibility for one person to manage." He put his hand on my shoulder briefly and walked back toward the silver Range Rover parked near the gate. I stood there holding the envelope until I heard the engine start and the tires crunch over the frozen gravel. Then I opened it. It was a notice from a Toronto law firm. 3 pages of formal language, with my son-in-law's name listed as the sole beneficiary of the MacAllister family property, including the cottage, the dock, the outbuildings, and all 200 acres of Muskoka shoreline. At the bottom was Claire's signature on what was described as an updated declaration of intent, dated 8 months before she died. I read it twice. Then I folded it carefully and put it back in the envelope. I drove 4 hours back to Sudbury. I made myself a cup of tea. I sat at my kitchen table for a long time, looking at the envelope in front of me. Then I picked up my phone and called the one person I should have called the moment Claire got sick. Walter Fenwick answered on the second ring. I hadn't spoken to Walter in almost 2 years. We had worked together at the same engineering firm in the early 1990s, and we had stayed in touch the way men of a certain generation stay in touch, which is to say badly and with long gaps between conversations. But Walter had retired from the Ontario bar after nearly 4 decades as an estate and property lawyer. And more importantly, Walter had been my closest friend since we were 19 years old. He listened without interrupting while I told him everything. The stranger on the dock, the envelope, the signature at the bottom of the declaration of intent. When I finished, he was quiet for a moment. "Read me the date on that signature again," he said. I read it. Another pause. "Gordon," he said, his voice shifting into something I recognized from the old days. A focused, careful tone. "What date did Claire go into the hospital for the first time?" I thought about it. "Late July," I said. The headaches had been going on for a few weeks before that, but the first hospital visit was the 22nd of July. "What month is the signature dated?" I looked at the document again. "June," I said. "The 15th of June." Walter let out a slow breath. "That's 6 weeks before her first hospital visit. But Gordon, here's the thing. I need you to think carefully. In June, was Claire herself? Was she functioning normally?" I closed my eyes. I thought about the last time I had seen Claire in June. Her birthday was the 3rd, and I had driven down to their place in Oakville for dinner. Claire had seemed tired. She had been forgetful in a way that had mildly worried me. She had confused the date of a family gathering twice during dinner. She had laughed it off, said she was just stressed. Her husband had smiled across the table. "She seemed off," I said. "But I thought it was just work." Walter said nothing for a moment. "I need you to bring me that document," he said. "And I need you to get me everything you can find about your father's original land transfer and any trust documentation from when you inherited the property." "I have it all," I said. "My father was meticulous. There's a filing cabinet in the cottage with everything going back to 1952. Then we need that cabinet before your son-in-law realizes what's in it." I drove back to Muskoka the next morning. I arrived before dawn. I used the key that had hung on a hook in my kitchen for 50 years, the original key my father had given me, the one my son-in-law didn't know existed because he had only ever been given the spare. I went to the back room of the cottage, to the gray steel filing cabinet in the corner behind the bookshelves. I took every folder inside it. I loaded 3 boxes into the back of my truck, and I drove to Barrie, where Walter was already waiting for me at his kitchen table with coffee and reading glasses. We spent 2 days going through the documents. On the second afternoon, Walter sat back in his chair and looked at me over his glasses. "Your son-in-law has made a very serious mistake," he said. He turned a document around so I could read it. It was dated 1987, the year my father died. It was the original transfer of the Muskoka property into a family trust, drafted by a solicitor in Huntsville, the MacAllister Family Property Trust, with myself and subsequently my descendants as the named beneficiaries. The trust had specific language about alienation, which Walter explained meant that no individual beneficiary could transfer or encumber the property without the written consent of the trustee. I was the trustee. I had been the trustee since my father died. "So Claire couldn't have signed it over," I said slowly. "She didn't have the legal authority to sign anything," Walter confirmed. "Even if she had wanted to, even if the signature on that document is entirely genuine, it means nothing. The property was never hers to transfer. It belongs to the trust." "But the signature," I said. "Does it look genuine to you?" Walter looked at me for a long moment. "No," he said quietly. "It doesn't." He pointed to the signature on the declaration of intent and then placed beside it a photocopy of a document Claire had signed 20 years earlier when my wife Margaret had updated her will. The 2 signatures were notably different. Claire's real signature had a particular quality to it. A slight leftward lean in the capital C. A habit she had developed as a teenager that had never changed. The signature on my son-in-law's document had none of that. "Someone had made a reasonable attempt," Walter said. "But it's not her handwriting." I sat with that for a moment. "So he forged it," I said. "That's what I believe, yes. But Gordon," Walter leaned forward, "forgery is one matter. But I want you to think about something else. Claire was 48 years old. She ran the trail behind their house 3 times a week. She had no family history of neurological disease. She was healthy. And then over the course of about 4 months, she developed progressive headaches, confusion, memory loss, and ultimately a brain hemorrhage. I looked at my old friend. "What are you saying?" "I'm saying I have questions, Gordon. And I think the OPP should have questions too." He said it carefully and quietly, the way a man says something he's been holding on to for a while. I couldn't speak. I looked out Walter's kitchen window at the gray February sky over Barry and felt something turn over in my chest, something cold and dense that had been sitting there since July. I want to say that what happened next was fast. It wasn't. The truth moves at its own pace, and no amount of anger or grief can make it move faster. Walter contacted a colleague of his, a property litigation specialist in Toronto named Patricia Osei, who had handled trust disputes for 30 years. Together they reviewed the documentation and drafted a formal challenge to my son-in-law's claim. They also filed a report with the Ontario Provincial Police Fraud Division regarding the forged signature. In the meantime, my son-in-law had retained his Toronto solicitor and was apparently under the impression that the process was moving forward smoothly. He put the property on the market with a firm in Gravenhurst. 2 weeks after I had driven away from that frozen dock, there was a listing online for the MacAllister family property at $4.2 million. When Walter called to tell me about the listing, he sounded almost cheerful in the particular way that lawyers get cheerful when their opponents have done something helpful. "He's listed a property he doesn't own," Walter said. "That's going to simplify things considerably." The OPP made their first contact with my son-in-law on a Tuesday morning in March. I know this because my neighbor at the lake, an 80-year-old former school teacher named Doug Whitfield, who had been watching over the MacAllister property since before I was old enough to drive, called me from his kitchen. "Gordon," Doug said, "there's an OPP cruiser in your driveway. 2 officers. Your son-in-law showed up about 20 minutes ago. I think he was planning to meet someone, maybe the realtor. They've been talking to him for quite a while now." He paused. "He doesn't look happy." "Thank you, Doug," I said. "You coming home soon?" "Not just yet," I said. "But soon." My son-in-law called me that evening. He was not calm. He said that I had engineered a campaign to destroy him. He said that I had never accepted him, that I had always thought he wasn't good enough for Claire, and that now I was using my money and my lawyers to manufacture a fraud case against a man who was simply trying to honor his wife's wishes. I let him talk. I didn't respond to most of it. When he paused, I said only, "The property belongs to the trust. It always has. Claire didn't have the authority to transfer it, and you know that." He hung up. 2 days later, Patricia Osei called me from Toronto. "Gordon," she said, "I need to ask you something about Claire." "Go ahead. Did Claire ever mention to you that she was having cognitive issues before the headaches began? Did she mention any difficulty with memory or concentration? Did she sign any documents in that period that you later thought seemed unusual?" I thought about it. "She did sign something," I said slowly. "A power of attorney. In favor of her husband. She mentioned it casually last summer. She said she was just being organized, that it made sense for him to handle financial matters since she had been so tired. I thought it was sensible at the time." Patricia was quiet for a moment. "Gordon," she said, "my investigator has been looking at some financial transactions in Claire's accounts over the past 18 months. There were several large transfers that don't correspond to any known expenses. They transferred out of Claire's accounts and into a joint account in your son-in-law's name." "How much?" I asked. "In total," she said carefully, "approximately $340,000. I sat down. "He was moving money while she was sick," I said. "While she was sick," Patricia confirmed. "And based on the dates of the transfers, it appears that he began doing so very shortly after the cognitive symptoms started, which suggests he knew about the symptoms before Claire's formal diagnosis and was acting on that knowledge." I looked at my hands. They were very still. "Patricia," I said, My friend Walter raised a concern with me about the nature of Claire's illness, about whether it might have been entirely natural. There was a pause on the line. "I know," she said quietly. "He told me, and I want you to know that the same concern has now been raised with the OPP. They're in contact with the coroner's office. They're requesting that the case be reviewed." I closed my eyes. "My daughter," I said. "I know, Gordon. I'm sorry. But if something was done to her, we are going to find it. I want to tell you that I handled the next weeks with dignity and patience. I want to tell you that I kept myself busy with practical matters and trusted the process. That is partially true. What is also true is that I did not sleep well. I drove up to the lake twice simply to walk the property and stand on the dock and look at the ice. I talked to Claire in my head the way I had talked to her mother Margaret after she died 12 years ago, asking questions I knew wouldn't be answered, and answering them anyway in the voice I imagined she would have used. The real answer, when it came from two directions at once. The first was the OPP. Their financial crimes unit had been investigating my son-in-law and had discovered, through a combination of phone records and bank documentation, that he had been in regular contact with a woman named Andrea since before Claire's illness began. Andrea was not simply a girlfriend. She was a registered practical nurse who had worked at the Oakville Clinic, where Claire had sought help for her initial headaches. She had access to Claire's medical file. In the text messages recovered from my son-in-law's phone, which investigators obtained through a production order, there were discussions about specific medications and compounds. There were discussions about symptoms and timelines. And there were discussions, clinical and cold in their language, about what Andrea described as accelerating the situation. The second direction was the coroner's office. When they conducted an expanded toxicological review of samples retained from Claire's original autopsy, they found elevated levels of a compound called lithium bromide. Not therapeutic levels. Not accidental levels. Sustained levels consistent with prolonged low-dose administration. The kind that would cause progressive neurological symptoms. Confusion, memory loss, elevated blood pressure, and over time, structural stress on the blood vessels of the brain. Walter called me on a Thursday morning. "Gordon," he said, "they've arrested him." I was sitting at my kitchen table in Sudbury with a cup of tea that had gone cold. I was looking at a photograph of Claire on her 16th birthday, standing on the dock at the Muskoka property with her arm around my wife, both of them squinting into the summer sun. "And the woman?" I asked. "Andrea was arrested this morning as well," Walter said. "She's been charged as a party to the offense. The Crown is treating it as a joint enterprise." "Both of them," I said. "Both of them." I looked at Claire in the photograph. She was laughing at something out of frame, leaning into her mother's shoulder, wearing a yellow rain jacket that had been too big for her, and that she had refused to take off all weekend. "Thank you, Walter," I said. "I should tell you one more thing," he said gently. "Patricia has completed the civil challenge. The listing has been taken down. The property is confirmed as belonging to the trust, and the fraudulent transfer documents have been referred to the Law Society. His Toronto solicitor is in some difficulty. So it stays," I said. "It stays, Gordon. It's yours." The trial happened in Brampton over 2 weeks in October. I attended every day. I sat in the gallery with Walter on one side and my sister on the other, and I listened to the Crown attorney lay out what my son-in-law had done to my daughter with the methodical patience of someone who has prepared for a very long time. The financial motive was established clearly. My son-in-law had gambling debts accumulated over 3 years at private games in Toronto and Mississauga, totaling over $800,000. He had believed, based on assumptions about Claire's family that he had never bothered to verify, that the Muskoka property was registered solely in Claire's name and would pass to him outright on her death. He had been wrong about that. Wrong about the trust. Wrong about everything, but he had still done what he did. The medical evidence was presented by 2 toxicologists and a neurologist from the University of Toronto. They explained how lithium bromide, administered in the quantities found in Claire's system, could cause exactly the progression of symptoms she had experienced. They explained how it could be added to food or drink without detection. They explained how it would interact with her existing health profile. Andrea's messages were read into the record by the Crown Attorney in a flat, factual tone that somehow made them worse than if she had dramatized them. There was a message from October of the previous year, in which Andrea wrote that it wouldn't be much longer now. There was a message from December in which my son-in-law replied with nothing but a single thumbs-up emoji. My daughter was still alive when those messages were sent. She was at home in Oakville, tired and confused, and telling me on our Sunday phone calls that she thought she was just overdoing it at work. The defense tried. They argued contamination of the samples. They argued that the financial transfers had been made with Claire's full understanding and consent. They argued that my involvement and the involvement of my lawyers amounted to a coordinated effort to frame an innocent man. The jury was out for 9 hours. On a gray Tuesday afternoon, they returned. Guilty on all counts. My son-in-law stood very still when they read the verdict. He did not shout. He did not cry. He looked across the courtroom at me with an expression I had difficulty reading, something between rage and a kind of exhausted disbelief, as though he still could not quite understand how a 6-7-year-old retired contractor from Sudbury had managed to do this to him. I held his gaze until he looked away. Andrea received a concurrent sentence as a party to the offense. First-degree murder, which under the Criminal Code of Canada carries a mandatory life sentence with no eligibility for parole for 25 years. The judge noted in his remarks that the premeditated nature of the offense and the exploitation of a position of medical trust were aggravating factors. Walter drove me back to the hotel. We had dinner at a place on the main street that had been there since the 1970s. Unremarkable food and strong tea and the particular comfort of sitting across from someone who has known you for most of your life. We didn't talk about the trial much. We talked about his grandchildren and about a fishing trip we had been meaning to take for 15 years and had never managed to arrange. When I got back to my room, I sat on the edge of the bed for a long time. I wasn't thinking about the verdict or the sentencing. I was thinking about a Sunday in August, about 8 months before Claire got sick, when she had called me on a warm evening and we had talked for over an hour about nothing in particular, about a book she was reading, about whether I should get a dog, about a hiking trail in Killarney Provincial Park that she wanted to do together in the fall. We never did that hike. I didn't go back to the cottage right away. The property had been closed up for the winter and I was in no hurry. I gave myself time in Sudbury, walking the streets I had walked for 40 years, letting the silence of an ordinary life settle back around me. In January, I drove north. The lake was frozen. The trees were heavy with snow. The dock was buried under a white drift that had come up past the railings. Everything was exactly as it had always been. Exactly as it had been when my father built the first room of the cottage in 1961. When my mother planted the cedar hedge along the east property line. When I had rebuilt the dock with my own hands and Claire had stood at the end of it at age 7 and yelled as loud as she could just to hear her voice bounce back off the water. I stood at the kitchen window and looked out over the ice. "What do I do now, Margaret?" I said to the empty room. "What would you have done?" I already had an answer. It had been forming for a long time. I called Walter the next morning. "I want to amend the trust," I said. "What kind of amendment?" "A conservation covenant. I want to attach a permanent conservation easement to the property through the Ontario Heritage Trust. No development, no subdivision, no commercial use. The shoreline and the forest stay exactly as they are. After I'm gone, the land transfers to the Muskoka Conservancy in perpetuity." Walter was quiet for a moment. "Gordon, that's a significant decision. The property is worth considerable money. There are developers who have already expressed interest." "I know," I said. "I don't need the money. I never did." That was the thing about this whole business that my son-in-law never understood. He thought the land was valuable because of what you could sell it for. He paused. "And you?" I was looking out the window at the frozen lake, at the snow-covered pines, at the gray morning sky over the water. "I think it's valuable because of what it is," I said. "I want to do one more thing. I told Walter about it. A fund attached to the local school board in Bracebridge, specifically for students from the Muskoka district who want to pursue careers in environmental science, conservation, or land management. Students who might not otherwise have the means to go. The kind of students who care about places like this one. We're calling it the Claire MacAllister Memorial Bursary. Every year, 4 students will receive full funding for their first year of university. Every year, Claire's name will be read aloud at the Every year, someone who never had the chance to meet my daughter will benefit from the life she lived. My son-in-law will spend the next 25 years in Millhaven Institution before he can even apply for parole. The property he tried to steal will never be sold, not by me, not by anyone. And my daughter's memory will grow in the minds of young people who walk these same forests and stand at this same water and feel the particular kind of quiet that you can only find in a place that has been protected from the noise of the world. There's something I've learned from all of this that I want to say plainly. Not as wisdom, just as fact. Men like my son-in-law move through the world with a certain confidence. They look at things and they see what those things are worth. They look at an old man with a pickup truck and they see someone who can be managed. They look at 200 acres of Muskoka shoreline and they see $4.2 million. They look at a woman who has spent her whole life in one place and they see an obstacle. What they never see is the root system. The decades of small decisions and careful work and quiet relationships and legal instruments put in place by people who loved something enough to protect it before the threat had even arrived. They never see that the ground they're standing on is not what they think it is. My father bought this land for $600 in 1958. He spent 30 years walking every inch of it. He knew where the bears denned in the fall. He knew which arm of the lake froze last and which bay the pike favored in May. He loved it the way you love, something that has no price. Which is to say, absolutely, and without calculation. He was smarter than anyone knew. And he planned accordingly. Greed makes a lot of noise. It negotiates and threatens and performs for cameras and sends lawyers letters and lists properties on websites and shakes hands on docks in winter. But the things that matter were built quietly, over generations, by people who never expected anyone to thank them. Those things last. Thank you for listening. If this story meant something to you, I'd ask you to share it with someone who needs to hear it. And please tell me in the comments where you're watching from. People from all across this country reach out after these videos. And every message reminds me that I am not alone in this, that none of us are.